So far, we've only looked at cases where liability depends on one single question. In this example, success for the claimant depends on clearing several hurdles, one after the other. If we'd fail any of them, our claim will be rejected. Our first uncertainty here is the breach of contract issue. And we think here that there is a 65% chance that the court will find a breach. If not, the claimant loses. If we clear this question, we must then show that the claim is not time-barred. We give this an 80% probability. Next, we need to establish causation between the breach of contract and the damages. We assign this a 90% probability. Now the model here treats each hurdle as an independent step, multiplying the probabilities to get the likelihood of the different outcomes. The final probability of success is here 0.65 times 0.8 times 0.9, which equates to 46.8%. So we have a 46.8% chance to establish liability. But it's important to consider how the actual decision maker will approach these questions. Listing too many questions or trying to create a very detailed model that catches every legal questions or questions of evidence is often not a good idea. Again, the key is to think, how do I think that the judge, jury, or arbitrators will assess my case? The goal is not to build a perfect map of all parties' arguments, but to create a useful description of what we think may happen so that we can make a good decision on how to proceed. But let's continue our detailed approach here. If we win on breach of contract, this win might create a spillover effect for the next hurdle. And the court may already be leaning in our favor when it is deciding if the claim is time-barred or not. And the same could happen with causation. Also, if we win on the first question, this may be because our evidence there is strong. If the other questions rely on the same witnesses and documents, the chance of success on those would also be higher. The key here is not just to ask how likely are we to establish breach of contract and then move on to the next question, but instead to ask, if we've already convinced the court on breach of contract, how likely is it then that we also manage to convince them on the time bar issue? If we won on the first two questions, how likely is it then that we also win on the third? This positive spillover effect is usually not as strong in reverse, when it affects the case in a negative way. Failure on one question could, in theory, affect the next in a bad way, but we would never see that because our first loss on the first question means that the case is already lost. There's no spillover to the second and the third question if the case has already ended with the first. Let's run through a few scenarios that shows how combining percentages like this isn't always intuitive. Say that we have a 10% chance of success on each of these three questions, and the amount here is not in dispute. This gives us just a 0.1% chance to win all three of these questions. 1 in 1,000. Now let's increase each probability here by 10 percentage points. That brings the total chance up to 0.8%. That's an increase of 700%, but it's still tiny in absolute terms. Add another 10 percentage points per question, and we reach 2.7. Even if each question is at 50%, the chance to win overall is just 12.5. Let's flip it around. If we're sure to win every question, the chance to win is obviously 100%, and the expected value is the full 100,000. But if we reduce each probability here by 10 percentage points, suddenly we're down to 72.9, with an expected value of 72,900. That's quite a significant drop in absolute terms. Let's look again at the qualitative assessment to see why these things are not always intuitive. Our assessment is that the claimant is likely to succeed on the breach of contract issue. The claimant is also likely to succeed on the time bar issue. And the claimant is further likely to succeed on causation. But the gut reaction here is perhaps to add all of these things together and look at the average. All right, on average, we are likely to win, right? But if we understand likely in each instance as meaning around 65%, the combined probability of success on all three questions is only 27.5. Few would describe that as likely to succeed. Research shows that humans are generally good at estimating average, but less accurate when it comes to estimating sums or understanding how things grow or compounds. This example that we just looked at here illustrates that difficulty. If a long sequence of questions results in a model that shows only a 1% chance of success or only a 1% chance of failure, the mathematics will be correct if applied in the tool. The question, however, is whether such an outcome makes sense in practice. Now, this judgment rests with a practitioner. If we don't think modeling each question separately reflects reality, then there is nothing stopping us from grouping them together into one combined probability. Perhaps by saying we are likely to win, and by likely we mean 65% or 50% or 45%. One model here is not necessarily more correct than the other. There is, however, no getting around that a claimant facing many questions, where he or she has the burden of proof, will have a tough path to push through. And this needs to be reflected in the model, regardless of if it's built in detail or not. Again, the goal isn't to build a perfect map of all parties' arguments and all the evidence, but it's to create a useful description of what we think may happen so that we can make a good decision in how to proceed. In the next video, we'll look at cases that has more than one path to success.